Welcome to Within the Frame, where we bring you today's most pressing issues from across the globe into focus. I'm Kim Mok-yeon. South Korea's Corruption Investigation Office for high-ranking officials formally requested that the police take over the execution of an arrest warrant for President Yoon Suk-yeol late Sunday, just a day before the warrant's expiration. The police, however, say the execution of the warrant contains legal issues for them to solely take over, effectively rejecting the request. They instead vowed to carry the process out in consultation with the CIO and relevant parties within the Joint Investigation Headquarters. Now, Yoon's legal team had been contesting the warrant's validity, arguing that the CIO lacks the authority to investigate charges of insurrection related to his failed martial law decree. Meanwhile, with Yoon's impeachment trial scheduled for January 14th, all eyes are on the proceedings as his legal team has pledged to attend and present their defense. Now, for more on the ongoing political situation in Korea, now we invite Song Se-ryun, professor of law at Kyunghee University. Welcome, Professor.
Thank you. Thank you for inviting me.
And also joining us is Lee Hyun, Dean and Professor of Law at Handong International Law School. Welcome, Professor.
It's good to be with you.
So let's start a discussion with Professor Song. So since President Yoon's arrest warrant expires at midnight today, attention has been focused on whether the CIO will seek a second warrant. Now, however, instead of this, the CIO has decided to delegate the execution of the arrest warrant to the police, and the police have effectively rejected the request. What is the key issue at stake?
Well, the whole thing is very, very unprecedented. So a lot of things have to be sorted out before they can effectively go ahead with it. Again, also this is a pretty significant test bed for CIO's effectiveness. Now, the police and the CIO has a little bit of rift because the police was asked to carry out the execution of the warrant, and they rejected it based on several grounds. One is they are doubtful of the CIO's authority to do it, and the jurisdictional issues has not been all sorted out. And although the CIO bases their jurisdiction for the abuse of power and the insurrection being the ancillary part of it, and also they are in charge of the Joint Investigation Headquarters, and the court has endorsed the warrant. Still, that point is still in debate. Now, it seems like they have sorted out the differences when they talked about it, and probably in the second attempt, the police would not be in executing the whole warrant, but they will be helping the CIO to execute it by dealing with the security forces at this point.
Right. And Professor Song, just hours ago, the Joint Investigation Headquarters submitted a request to extend the expiry period of the arrest warrant against President Yoon. So with this, how do you expect the execution of the arrest warrant for President Yoon proceed going forward?
Well, what we just discussed was the strategy and how they would execute it, and the collaboration mode seems to have been discussed and for now sorted out. So police being more active in dealing with the security forces, while the CIO team will execute the warrants. But that does not eradicate the underlying issues about the jurisdiction. I think the president's side will continue to say the CIO does not have the jurisdiction because by law, the CIO does not have it. But because of the joint investigative nature, and if they are successful in court, saying that they have the jurisdiction over the abuse of power and the insurrection is a major part of it, and because they have already the endorsement of the court issuing the warrants, it's going to be an interesting fight between the two. Again, the unprecedented debates that will probably leave some good precedents.
Right, so like we've been discussing, President Yoon's side has been raising concerns about the CIO's authority to investigate charges of treason, and his lawyers argue that since the CIO chief does not have investigative command authority, the execution of the arrest warrant was unlawful, and they threatened to file a complaint. Professor Lee, why is there a controversy over who holds the investigative authority in this case? And also, do you believe the investigative authority should be transferred to the police?
Well, the question, I guess, with respect to the jurisdiction of the CIO goes to the question about, what is their competence with respect to investigations and ultimately prosecutions? Because when the CIO was established about 4 years ago, this was in response to the President Park Geun-hye's impeachment, and there was a desire to sort of have an investigative body and a prosecutorial body that would investigate corruption at the high levels of government. But in the context of this specific charge against the president, let's say for insurrection, the competence of the CIO is not actually within that charge, because about 4 years ago, that charge of insurrection or the crime of insurrection was taken away from the CIO and left with the police to investigate primarily with respect to that crime. And so when it comes to the CIO's jurisdiction, because the president generally has immunity against prosecution when it comes to all crimes except insurrection and treason, there's a legal question that arises as to whether the CIO exceeded its own authority with respect to investigations on that basis with respect to insurrection. And so this becomes, I think, the main question here is the CIO's ability to be able to investigate this, and whether or not the police, in fact, because it has the primary authority to investigate these such crimes as insurrection, whether the police should in fact get the main sort of role here in terms of the investigative power and sort of scope of this investigation against the president. I think, as Professor Song sort of referred to earlier, there may be some an interagency dispute as to who will take the lead and take the prominence with respect to this high-level prosecution. And I think this becomes partly maybe a bureaucratic dispute between the two sides.
Right, so the dispute regarding Yoon's arrest warrant is reportedly involving Articles 110 and 111 of the Criminal Procedure Act. Professor Lee, could you explain for us, our viewers, what these provisions entail?
Sure. So the Criminal Procedure Act provides that in certain contexts, certain places cannot be searched and documents cannot be seized, specifically if they relate to military secrets or public secrets. And so Article 110 and Article 111 of the Criminal Procedure Act provide that unless there's permission granted explicitly by the person in charge, and that in case is the president, then the police or any other investigative body cannot search and seize documents as it relates to these public secrets or military secrets, because the people who are investigating don't have the security clearance to be able to view those documents. But the balance here is that this is in part an interpretive question, because in both of those specific provisions, if there is some prejudice to national interests or state interests, that claim of sort of denying searches and seizures could be balanced against sort of the interests of the state. And so ultimately, this becomes a legal justiciable question that probably will have to go to the court to decide whether or not the president in this case could exclude the search from the police and the investigative officials from being able to take actions with respect to these documents that may or may not be seized in the context of this investigation.
So it seems like the ball is in the court, but in a rare move, the CIO specified the exception provisions of Articles 110 and 111 of the Criminal Procedure Act in the arrest warrant. President Yoon's side has objected, calling it illegal and invalid. Professor Song, as a legal expert, what is your opinion on this?
Well, I agree with Professor Lee that this has to be determined in court. However, in the initial stage, this has taken on the characteristics of the battle between the different parts of the government. The balance of power between the three separated government branches are exerting and testing the limits of the power. Now, the court is saying that, well, the Article 110 and 111 do not apply because we're not looking for documents or military secrets. We're looking for a person to arrest them. But the counter argument could be that if you open up the premise, you don't know what's going to happen. And the presidential, the authority and the kinds of things that holds in their promise cannot be easily tested. So in that sense, this is a kind of a turf fight, but I think this has to be tested and go to the highest court to be determined. But I think that you could have avoided all this by President Yoon just voluntarily submitting to the investigation because there is a matter to be investigated. But of course, even in that case, probably their objection to the jurisdictional power of the CIO still would be an issue. So I think that this has to be sorted out in more than one different levels.
Mm-hmm. Now let's also look at the progress of the impeachment trial of President Yoon. Ahead of the first trial session on the 14th of January, 2 preliminary hearings have already taken place. And although President Yoon's side requested for more additional preparatory hearings, the Constitutional Court did not accept this request. Can we interpret this as the court's intention to proceed with the impeachment trial as fast as possible, Professor Lee?
Well, I think the court is moving with very deliberate speed on the impeachment process with respect to the president, because obviously this is a high priority case, of the highest priority when it comes to this question, because there are a number of other impeachment trials that are ongoing as well, right? Not to mention the Prime Minister Han, as well as other officials within the Yoon administration who have also been impeached. But with respect to the court's process and the dates that it established, it seems to really clearly indicate to everyone, including President Yoon, that they intend to move this forward and meeting the deadline set by the Constitutional Court itself with respect to impeachment proceedings. But also the court needs to be aware, I think very consciously aware, that 2 of the justices that are currently on the court, their terms will expire in April. And so I think what's going on here as well is because there's a potential stalemate that is occurring at the highest levels of government with respect to appointments of constitutional judges. As we saw, Prime Minister Han did not appoint the justices, but also in this context, if the current acting president is given the opportunity now to further appoint 2 more justices, this will further, I think, cause chaos within the constitutional branches of the government. So the court, I think, is very consciously aware of what's going on in terms of the broader context. And I think given the interest of the whole country to know exactly where this will stand with respect to President Yoon and to provide clarity for the country, the court is moving with deliberate speed in terms of trying to conclude this, I think, in the fairest and most efficient manner possible.
Right. Now, meanwhile, the National Assembly's impeachment committee has decided to exclude treason charges from the impeachment trial, leading to further political disputes in the National Assembly. What is the background behind the National Assembly's decision to exclude such charges, and how should the Constitutional Court's acceptance of this be interpreted? Professor Song.
Now, this is an interesting development because if you look at the impeachment trial, the answer that the Constitutional Court is seeking is whether to remove the president from the office or not. And the criminal element is not really essential part of it. There is a constitutional question to it. So I think that the acceptance of this, the exclusion, would be the Constitutional Court saying that there is a constitutional question to be answered, and their primary task is not to determine whether there was a criminal violation to be committed. Now, the question of insurrection is closely tied to the abuse of power and the constitutional violation, because if the declaring a martial law is indeed, as the President Yoon side refers it, the exclusively presidential governing activities or presidential prerogative, then that's not an insurrection, as they claim. But if the bringing of the armed services and also their attempt to shut down the National Assembly, if that is added to it, then it's not a martial law, but insurrection. So you're looking at it from two different angles and very, very differently. So I think that the Constitutional Court is given that kind of nuances. There is enough constitutional question to decide whether to remove President Yoon from the office or not at this point.
Then, Professor, President Yoon's side has also opposed this exclusion, claiming that removing treason as grounds for impeachment acknowledges that the impeachment resolution itself is invalid. What's your thoughts on this?
Well, they're raising this as procedural issues. The Constitutional Court has this case in docket only because the National Assembly passed the resolution with more than 200 yes votes. They heavily relied on the insurrection, the evidences, and his violation of a criminal element. If that's the case, then they are questioning that the National Assembly's passage of the resolution itself has to be revisited if they're going to remove the criminal, the insurrection charges. I think that that's a far-fetched argument at this point because everybody knew that the martial law and insurrection has that distinction of the power, and those who voted for it knew this distinction, and they probably would say, well, we'll vote in the same manner at this point. So that's my personal opinion. But I think that the president's side is making all the legal arguments possible, but some are good, some are not so good.
Mm-hmm. Well, the official impeachment trial for President Yoon, like I've mentioned as in the beginning, will begin on the 14th of January. Professor Lee, how do you expect the trial to proceed? And do you think the trial procedures may be concluded possibly earlier than expected?
Well, I'm not sure if it's going to be earlier than expected, but I think the court has signaled again that it's going to move forward with, very quickly as much as it can in terms of how the process will then develop. Because this is such the highest profile case the Constitutional Court is dealing with, the questions about whether or not there's going to be a fair trial, whether all the evidence will be considered, carefully, all the arguments will be deliberated upon. I think on the President Yoon side, there's the question as to, will we have enough time to bring forth our case? And then, the president has indicated himself that he is going to appear at the Constitutional Court to sort of make his case as to why impeachment is going to be improper in this situation. So, I mean, there's so many moving parts to this because we're talking about, again, evidence, we're talking about documents, we're talking about witnesses, we're talking about, all the kinds of things that you might expect to see at a trial with respect to the establishment of the facts. This is not going to be necessarily that easy. And I think President Yoon, his legal team, has an interest to try to slow things down as much as possible. And I think that has a couple of purposes, not to mention the political angle of this, because the longer this is drawn out, maybe he gets more support from the public. But then, on the legal end of things, to be able to sort of put forward the argument about why the impeachment in his case was incorrect or not legally feasible, his side is going to argue, of course, they need a lot more time to sort of present the fullest case possible in fairness to him as a sort of defendant in this impeachment trial. So I think the court, has to have a balancing act here because at one point, of course, you want to have a speedy trial. And every defendant is clearly entitled to one. But on the other side of things, President Yoon, I think, really wants to present at least a fulsome case in his case, with respect to defending his actions. And so I think this is where the balance is, and the court has to walk this balance between making sure that his rights are respected, but at the same time, the public and the interests of the state here are for a clear, decisive, and speedy trial that will settle this question once and for all.
Now, President Yoon's side, which has been uncooperative with the summons investigations and the searches related to the treason investigation, has stated that they will attend the impeachment trial and express their opinions at an appropriate time. And they have consistently maintained that the impeachment trial takes precedence over the investigation. Professor Song, how might their stance affect the outcome of the trial?
Well, that's their legal strategy. I think, I'm agreeing with the Professor Lee's assessment, but my guess is that the president's side might prefer a constitutional argument rather than answering all the evidences that comes out on the insurrection charges. Probably he'll try to say that, again, this martial law declaration is a presidential governing authority, and if this becomes a battle between the different branches of government, then the judiciary should stand down and exercise judicial abstainment in the areas where the executive branch or the president has an authority. I think that argument is sometimes is a good argument, but sometimes at this point, probably not so good argument. But nonetheless, the president's side will make that argument very, very forcefully. Judiciary has no place in determining or deciding the governing activities of the president when it comes to declaring the martial law, because the judiciary does not have all the information that goes into making such determination. So I think that when the president says he will come on to the trial itself, probably he'll try to make the argument, a very political argument, that the president has this power and there's a reason to do it, and you should not believe all the presses or the opposition saying that this is a disruption of the constitutional order. I think that he will make long arguments, as is the case when it comes on to TV, but there's something to watch for. This is distinctively constitutional argument. There's a legal element to it. If he wants to gloss over that part with the political argument and trying to appeal to his supporters, probably the constitutional justice will have a hard time trying to decipher between what's distinctively constitutional and what's political.
Right, so it's going to be a difficult decision for the judges, but let's hope for a swift decision, as this political turmoil has been causing a lot of disruptions in the country. I'm afraid we'll have to wrap up our discussion right here. Many thanks to Professor Song and Professor Lee for your insights tonight. We appreciate it.
Thanks for having me on the program.
Now, that'll be all from us on Within the Frame. Be sure to tune in next time as we continue to explore the stories that matter. Until then, stay informed and engaged.